All right, good evening, everyone, and welcome back. We do have quite a bit of material to cover this evening, so we're just going to jump right into it with our learning objectives.
Oh, yeah.
We're going to distinguish between express and implied, bilateral and unilateral, and executed and executory contracts. We'll explain the difference in valid, void, voidable, and unenforceable contracts. We'll identify the essential elements of a valid contract. We'll explain the difference between an assignment and a novation. We'll also give examples of what constitutes a breach of contract. We'll list reasons for the termination of a contract. We'll describe the types of contracts used in the real estate business. We'll describe different types of listings and how they may be terminated. We'll also identify the information needed for a listing agreement. We'll compare a listing agreement and a buyer agency agreement. We will define types of leasehold estates and summarize the requirements and general conditions of a valid lease and how it may be discharged. And we're also going to describe different leases and when they are used. We'll discuss the potential use of an option and a land contract. So quite a bit of stuff there. So we're going to go and move along. A contract is a legally enforceable agreement, and it's either to do something or not to do something, to perform or to forbear. When you do a contract, a lot of the times it'll be do this and I'll do this, and at the end you get the house. You do this and I pay this, and so on and so on.
It's also like, don't do this.
Yeah, and you can also have contracts to say that you will not do something, like you won't do something on my land or something like that. So contracts are based on those two things, either to do or not to do. All right, so express and implied contracts. Express, the parties state the terms and show their intentions in words, either oral or written. So an express contract would be like if I were to say, Wyatt, I will hire you at my business and I will pay you $100 an hour. That's express because yeah, you want to work for me?
Yeah.
All right, how about 3,000?
I'm out of school right now.
3,000.
I think you got other people wanting jobs too now.
Yeah.
I have a resume here somewhere.
Yeah, very good. But we created an express contract because I orally told you and you accepted. So it could be either oral or written. But most real estate contracts are express contracts. They have been committed in writing. And that's under the statute of frauds, which we talked about the other day a little bit, that all real estate contracts must be in writing. Certain types of contracts must be in writing to be enforceable in a court and law. So most real estate contracts are going to be express. An implied contract is an agreement of the parties is demonstrated by their acts and conduct. So if someone were to come in and, I think,
What are you on?
implied,
Implied is through, remember, expressed is verbal.
Right.
Implied is your actions.
Right.
So, like I said before, is if in a situation, say that Travis, I'm going and I start showing him properties and all, but we never actually have the formal written contract or formal, hey, can I represent you? I just go showing properties.
oh, that's
My
right.
actions end up would be what? Well, if Wyatt, if you see me showing Travis properties, what do you think I am to Wyatt if I'm showing properties? I'm his who? I'm his agent, right? So that's the implied is I end up, my actions could create a contractual arrangement.
Even if they don't have a
And then
contract.
the same thing you're talking about with paying you to work for him. Express would be, he states, I will pay you X amount to work for me. I'll pay you $15 an hour to come in and do this. Whereas if you just came in and every day when you came in, he just hands us $60 when you leave and says, see you tomorrow. Next day you come in and he just hands you $60 and says, see you tomorrow. You then have a implied agreement that you just get paid $60 a day to work. But there was never an expressed oral
There was never
contract
written.
about it. Yeah, it was just kind of
orally.
you just-
Oral, yeah.
yeah, you just kind of implied that I guess when I come in I get $60 when I leave every day.
Yeah.
So there's no real express oral or written agreement.
So those are the two types of agreements or contracts. And like I said, most of them are going to be expressed for real estate. And then we have bilateral and unilateral contracts. Ms. Davenport, what does that word mean?
Huh?
One? How many?
Oh, Bob means
I mean, it's
two.
uni. It's like Uno. You ever played Uno?
Like one of those?
Or a
Yeah,
bicycle.
one.
Oh, okay.
So a bilateral contract is going to be, a bilateral contract is going to be between two parties, and a unilateral contract is going to be between one party. An independent contractor agreement, that's going to be bilateral because it's just the independent contractor.
Who are those between asking? Who's the two parties to an independent contractor agreement? No, not you. Ask them.
Oh.
Pick somebody and ask them.
Okay. Why? I'm picking on you today.
That one, I don't know.
It's between two people. It's going to be between the contractor and the.
What is my title here?
Well, you're broke.
I'm the broker.
Uh,
So I'm the broker, and what's Travis and Stefan? What are they?
agents
So the independent contractor agreement's between who?
and broke.
Me
Or
and who else? And the agents. So it's between the broker and the agents. Now, let me go a little bit deeper, Wyatt, real quick. Travis, what did you say yesterday in regards to, do I sponsor you personally?
No.
Who sponsored you?
Nobles Realty Group LLC.
So in that situation, Wyatt, who is Travis's independent contractor agreement with? Me or with Nobles Realty? You see how that works?
Yeah.
So there sometimes may be a contractual arrangement between a business and a salesperson. Now let's say Travis started T-Rex Realty Group. Okay. Well, I may have to designate his business underneath my brokerage as a operating team. And in that situation, that also could be there. So you got to be very careful in how this is coming together. You see what I'm saying? Does that make sense?
Yeah, I got you.
All right, go ahead, Steph. Everybody else good?
Everyone else good? Online?
Okay.
Are we good online? Do we have everyone?
Yep.
Okay, what about a lease? It's a bilateral, so there's two parties. Who's that between?
And the
Buyer?
seller.
Tenant and landlord, correct?
Or landlord. Oh, okay.
You got it. What about an option to terminate? That's a unilateral contract.
That would just be the owner.
Watch yourself there.
Not the owner, but
You're right. Stay on it, but not owner. Who's buying?
the seller.
Nah,
Oh no, who's buying?
stay on it. You're right.
The buyer.
There you go. There you go. The buyer would have the unilateral option to terminate.
The reason it's unilateral is because the other party is not promised to do anything. How is it promised to perform or to not perform something?
Right. Let her finish her thought. She's got a thought.
So the buyer would terminate, but also would the seller be able to terminate? Okay.
Then
Not in that, because what's happening is, think of it this way, you're selling. So you're selling your house. I want to buy your house from you. Okay? So I put a contract in. You want $400,000, so I put a contract in. but I say, I want 10 days to do inspections. You promised me you're not going to sell this contract or sell this house from underneath me while I do my 10 days of inspections. So if Ms. Davenport comes in and says, I got $500,000 cash, I want to buy it right now, you can't terminate because of why? You're in a contractual agreement with me and you gave me the right to go do what? Do inspections. Even though she walks in with $500,000 in cash, you can't do nothing because I had the right to do my inspections. So it only allows me to breach the, or not breach, but to break the contract. You as a seller are locked to it. You see how that works. And that's also going to the second one. Those two options there,
Option to purchase.
they're both coming in from the buyer's perspective. Does that make sense?
Both unilateral, both buyer.
Because the seller is locked to that contract and they're agreed to do your inspections. So what do you think people do? Well, if you're a seller, do you want me having 10 days to do inspections? What do you want? You want to cut that in half so if I bag out, I'm out quickly and you can grab Ms. Davenport's. So a lot of times from your side, you're going to say, no, you ain't getting 10 days. We're cutting that in half. You get 5 for $100. So for $100, you give me 5 days, or I'm giving you 5 days. If you can't do it in 5 days, sorry, get out of here because I got another person waiting for me. You see kind of how that works? But from a buyer side, I want it as long as possible. From your side, you want it as short as possible. Make sense?
And one thing, like I was saying with the unilateral and bilateral, the reason like an independent contract agreement is bilateral is because I am promising to pay Justin a commission, but Justin's also promising to sponsor me and to kind of be the, or I guess the brokerage is promising to sponsor me. So there is an agreement between both of us that we both have duties to perform in that situation. Whereas the unilateral, like the option to terminate, the seller is not promised to do anything. The only people that, it's just a contract that states that one person can do something. This person can, the buyer can terminate the contract, but there's not a two-way, the seller doesn't have to promise anything in that situation. It's just the buyer who has the right to perform an act, basically.
And I forgot to say, under the statute of frauds, y'all probably go over that a little more. I think is it contract forms, Justin?
Yeah, probably.
There is one exception to this rule that all contracts must be in writing, and that's if it's for a lease for a year or less. Anything less than a year, you don't need to put it in writing. That's the only exception to that rule. All right, listing agreements. An exclusive right to sell. That's a bilateral contract. Who is that between? Anybody online? Anybody online know?
Miss Sheldon.
Yeah, Miss Sheldon.
Every time.
What was the question?
Oh, I heard somebody else.
Oh, look, a volunteer.
No, I asked what the question was.
You volunteered, so
Who is the exclusive right to sell contract between?
it's a bilateral contract. Who is it between? Bilateral 2, right?
Mhm.
So who is the exclusive right to sell contract going to be between? Which two parties?
The buyer and the seller?
Okay. Anybody else?
No, explain why.
You say buy,
Well,
you say
She
buy.
said buyer and seller.
Buyer and seller.
Oh,
yeah.
Is that correct?
No, it's not correct.
Okay.
It would be the seller.
They're on it.
You're close. You're very close. It's actually between the broker and the seller.
But wait a minute, Professor, I got a problem. Hold on.
Here we
Oh
go.
my
Every
goodness.
Oh, my
This guy.
God.
Hold on, I got a problem.
Problem child in the back.
So many questions.
But wait a minute. Wait a minute.
Yes,
I'm
Mr. Knowles.
I am a real
Yes,
estate
no.
agent.
Uh-huh.
Okay.
We all got a real estate, we're getting our license. I'm a real estate agent. And I go out, you're telling me if I go out to Miss Davenport and she ends up, she's wanting to sell her house, I go out, Miss Davenport, and I come over to you and I give you this exclusive right to sell and you sign it and it's gonna have Miss Davenport and then I'm gonna sign off on it. So it's between me and Miss Davenport, right, Travis?
Nope. Because
But I'm the agent.
you are the agent, but every contract that you, I
You're a
see.
broker and an agent at the same time, right?
The key is the broker. Now, It has to be the broker owner, not just a broker associate.
When I go out and sign a.
See what I'm
exclusive-
saying there? You got that.
When I go out and
Yeah.
sign an exclusive right to sell agreement, I get the seller to sign saying that, we have the exclusive right to sell their property. And then I sign, but I sign as an associate of Noble's Realty Group. I'm not signing that Travis Stahl is the only person that can sell this property. I'm signing that Noble's Realty Group is the only company or brokerage that can sell this property. And if it wasn't a company, if it was just Justin, I would sign on behalf of Justin, that Justin is the only one who can sell this property, but he can use me as an agent to sell the property. But it's still a contract between the brokerage and the seller.
And the reason I jumped into that was because I actually had a student today ask me that question.
Today, really?
Today,
That's why I
yeah.
said it's a tricky.
That literally was like, but I'm a real estate agent. And I went and procured Miss Davenport, so that's my client. So she's mine. And I was like, no, it's not your client. It's your brokerage client, not the agent. So when you sign these contracts, like Travis and Stefan said, when those are signed, they're signing on behalf of me.
Yeah.
The broker owns those contracts. Now, of course, in the independent contractor, I can say if Travis decides to leave, he can take them with him.
Yeah.
But if it's under contract, it stays with the brokerage. They won't let him take that client off. Does that make sense? But you as an agent, even though you may sign and all, they're not yours, even though they may be your own family members. If that makes sense. Go ahead, Travis. You were going to say something. So.
I was gonna say, and that's kind of one of the things in the independent contractor agreement that we kind of set up is that for the most part, I don't want to say all the time, but for the most part, I don't sign anything on as Travis Stoll. I never sign anything that locks me into any contract. I sign everything as an associate or as an agent of Noble's Realty Group. So I'm never signing papers that's locking me into a contract. I'm signing papers that locks Noble's Realty Group into a contract, whether that's buyer or seller. And that just kind of helps if anything happens to me. It's not like when now this person's in the middle of a contract and it's just kind of there. Like now there's nothing going on. It still, since it's under the brokerage, it can be passed around and stuff like that. And so that just helps it helps where there's no unforeseen circumstances that can cause kind of situations like that.
And we're going to go over these types of contracts actually in this session.
Yeah.
So we'll go over more of that. But what about an open listing? It's a unilateral. What is that for? So it's a little
Put it
tricky.
more in their terminology. Wyatt, what is a open relationship?
Tell me anything you want to.
There you go, Miss Davenport. She heard it. That's the same thing.
Okay.
It's basically in the real estate world is whoever gets it. So say, come back to this real quick. Travis, you're selling your house all of a sudden. And Travis, since you're selling your house, bro, you want to get the best deal, right? You're the seller.
Absolutely.
He wants the best seller.
I want my money.
That's right. So Wyatt, you show up to Travis and you say, hey, I want to list your house and I want to exclusively write to, I want to have exclusive right. And Travis says, no,
Get out of here.
not going to happen. You can put your sign up, but I'm not just going with you. I want as many brokerages working for me as possible. Okay. So y'all sign an open listing. Then Miss Davenport the next day comes out and says, well, let me sell. Well, she says, sure, go for it, Miss
You
Davenport.
can put your sign up here too.
Go put it out there too. And it just keeps going and going and going and going. And guess what ends up happening? He has a ton of
20 signs.
20 signs out here. And then what ends up happening though is that the point is not only are you individually, each one of us, say we all put one out there. What happens is we're not only competing amongst ourselves, but guess who also we're competing against? That guy sitting right up there. Because the seller can also sell the property, which means
Y'all might have a sign out front, but if
they
I have a friend that wants to buy it,
Yep.
I can sell it as a
Yep.
Like I can sell it as a for sale by owner.
Does that make sense?
And we'll go into more detail on that
Yeah.
too.
I like that analogy.
Makes it
Yeah,
simple.
that's a good one.
Yeah, now I can.
Bilateral and unilateral contracts. Buyer and tenant representation agreements, they're bilateral. A purchase agreement is also bilateral. Number two. Executed and executory contracts. So, let's say everybody, we put in a contract, me and Wyatt, we put in a contract, I want to buy your house, and we're in the process of completing all the things that we need to do to purchase the house. Executory is an enforceable contract in the process of being performed or fulfilled. So if we're still working through the contract, we're in an executory contract. And then there's executed contract. All promises in the contract have been made, and that'll be after everything is done, it's closed, it's funded, all of that. That's when the contract will be considered executed. Does that make sense?
So yeah,
Executory is in the process.
Yeah, and then executed.
Executed is
Just the before and after.
you got it. Okay, so now we're getting to the essential elements of a valid contract. There's going to be offer and acceptance. That would be the first thing that you would have to have. Buyer will have to come, make an offer, and the seller will have to accept that. And then there's consideration, and that could be anything of value. It doesn't have to be just money. Justin did a good analogy one time. What if my mother wanted to sell me a house, and I tell her, I don't have any money. What can I give you? How about my love and affection? Is love and affection consideration, Ms. Davenport? No? She said,
You can't go around with love and affection.
Could it be considered a gift?
Sorry.
And that
well, if she wanted to do that, she could gift this property, yeah.
Let me ask you, I want to go back real quick to Ms. Davenport, and then I want to get back to hers as well. Ms. Davenport, if you're married to your spouse, okay, do you sometimes, would you give your spouse gifts and things to that nature? Are you going to charge them a fee for that?
Yeah.
Every time.
Every time.
Every time.
Right?
But most of the time, that's not going to happen, right?
No.
But it's because the fact is if you give your spouse, for example, say your husband gives you a diamond ring, a brand new diamond ring. Do you do that and then say, well, here's the diamond ring, honey, now I need some money? No, what is it? It is, I love you, here you go. So in that situation is love and affection a proper transference of, or through consideration, is a proper transference through the consideration clause? Yeah, it is.
Because like you said, it's anything valuable.
Beauty is in the eye of the beholder.
And it comes
could
to
be
this
anything.
situation is that when you're looking at this, you have to understand that value, some people have so much money ain't worth nothing. They would rather have the love and attention. So it comes to value, like I tell people all the time, it's always use the water bottle, and I don't have a water bottle with me. But say for example that this bottle here, okay, this empty green tea bottle, say this is full with water, okay? So I go in there, I go fill it up with water, I have a bottle of green tea, or of water in this green tea bottle. You wanna buy this from me? I've already opened it, drank out of it, filled it up with water. You wanna buy it?
Not really, but maybe.
Yeah, but to me, I drank out of it, I've done that, it ain't worth nothing to you, right?
Yeah.
Okay, all of a sudden, all the water in the world's gone, and this is the only water left.
Anything you want.
Do you see how that works there? Is in this situation is, at one point, something's not worth nothing. But in a different situation, it's worth a ton amount of money. That's why we're there talking about consideration. Consideration's not always going to be money. I may end up, you may be selling your house, and I may have no money, but I have a yacht, for example, and you're retiring, okay? Well, I may say, can I exchange with you my yacht for your house? Could we do that?
Both
Is
agree?
there any money?
No.
We're just exchanging stuff. That's when you're reading this, because on these questions, they're going to kind of give you little tricks. Think of it from the situation. Now, let me ask you this. Does it have to be of the same value? No. It doesn't have to be the same value. What if your child, like you're saying, say your child goes and they wanna, you're getting older and you know you're about to pass. Are you gonna charge your child money to buy your house? Money ain't worth nothing if you're dying, right? So you may just wanna say, honey, I'm gonna give you my house. I just want you to be around until my last days. That's valuable to you, right? They'll be there. So when you're reading these questions, don't always think it has to be cash. It has to end up being something of value to that person. Does that make sense?
Yes, however, if you are trading, even though the yacht and the house are not at the same value, wouldn't that affect the bank?
In regards to, well, we are talking in terms of everything's paid for.
Okay.
Does that make sense?
Yeah.
If there is a note, they won't let you do it. It has to be paid in full. But in the situation, if it was paid in full and y'all just trading, that's fine. But anything that has a mortgage on it, it has to be paid cash. Like they actually have to, you would have to sell the yacht, take the money, pay off the note, and keep the remainder. You kind of see what I'm saying there?
And buy a smaller.
Yeah,
I actually looked at yachts recently just because I wanted to, and
Because he's paying.
they are worth a
Yeah.
lot of money. So
Did
Could
you
be.
use Mr. Wyatt's credit card on that one?
I would like to.
Every time
It's-
with the credit card.
You might see.
Once we find it, I'll promise everyone a shopping day. Let me know when I find it.
It's
I will
just a couple
remember
$100,000.
that. I will remember that.
She's got that wrote down, Wyatt. You better watch out.
I'll get the cheapest one. It's just
Replay the video.
$100,000. Or well, probably 200,000.
That was express.
There you go. There you go.
There you go. I'm always teaching.
So yeah, consideration can be anything of value. I don't know if we've gone over earnest money. Do y'all know? We haven't talked about earnest money yet, have we?
No.
Okay, well, earnest money is basically something you put down, a buyer will put down, it's just to show serious intent that I'm gonna buy the property. And earnest money can never be a consideration. It is not consideration.
It's just like a reservation, but get the money back.
The earnest money, it goes towards
It goes towards
the closing, yeah.
So the buyer will put, so it's usually 1% of the purchase price. So
Right.
if you're buying a $350,000 house, you'll, for the most part, usually in the contract, it'll say like, okay, well, the buyer will also put $3,500. They'll give that to the title company. They'll write a check and give it to the title company, which basically will show like, here is some money to prove that I'm really serious
I'm gonna
about
buy the
this.
house, yeah.
And then whenever it closes, if everything goes through, the contract goes through and it's executed, that money will then go towards the total closing. So then the buyer will only have to pay the $346,500. Like they'll cut that out of the closing costs.
And you may see a question on the test that says, is earnest money consideration? I think I remember
I
seeing
think so,
something like
yeah.
that. And so just remember, earnest money can never be consideration. Another essential element of a valid contract is, yes, problem child.
Do I have to have earnest money in a contract?
No.
No, not necessarily.
You don't,
No, you don't.
but it's a good idea to put it in there.
So if me and White decide I don't want to deal with that crap, but we don't have to do it.
I mean,
It has to be agreed upon.
There
Like
you
the
go.
seller
it's
and
agreed upon by both. It
Yeah.
trumps everything.
Written.
And in the same way, like we had when my brother bought his property, we were kind of going through the contract and then some stuff came up here and there. And basically everything was going fine, but there was just some speed bumps we were going through and the sellers weren't sure if we were serious or whatever. So we actually put 3%. Instead of, it was $300,000 and instead of putting $3,000 in earnest money, we did $7,000 in earnest money. So we did like 2.5 times because we were just like, we are serious. And like, it doesn't change I mean, it's the same price for us at the end. We're still paying $300,000. It doesn't change anything.
Price, yeah.
But it just shows them like, we're not, this is real, because what that earnest money covers is if we back out after the option period, or if we like unlawfully break the contract or breach the contract, the earnest money goes to the seller. So basically what we're showing is like, we are serious about this, because if we get to 2 days before closing, we just go, all right, peace, we're not doing this anymore, we lose that
We lose
$7,000.
$7,000.
So that's kind of why we were putting that extra money up. It's just like, no, we don't want to lose this much money, so we are going to go through with this.
Yeah.
we
Well,
promise
I
that.
could've
So.
just kicked you off and then just kept the $7,000.
Well, there are ways that if the seller breaks the contract, the earnest money goes back to the buyer.
Yep.
So basically, if anybody but the buyer breaches the contract like unlawfully, the earnest money just goes back to the buyer. They give them the check back or whatever. And so,
And so in case they pass away in the process, then that money will go back to the family.
yes.
Okay. Sorry, my head is just all over.
No,
the
you're good.
place.
It's a lot of material
It
today.
Yeah, yeah.
It's like, we're only, I mean, we're not even halfway,
Yeah.
probably.
Take the gore.
Okay, so another essential element of a valid contract is legal purpose. If I were to go and I wanted to purchase Travis's house because I wanted to grow marijuana, is that a legal purpose?
No.
Okay.
Depends Colorado.
There it is. Yeah,
There it is. Well, not in Texas.
yeah, not in Texas.
Yeah.
Maybe someday. But
Don't get ecstatic there.
hey now.
Hey, you got a cool professor.
He's a chill
Yeah.
guy.
What's up, students? We're gonna learn some stuff.
Yeah.
So it has to be a legal purpose for purchasing the property. And then legally competent parties. If the party is not legally competent, and if they are mentally handicapped and they can't, then you don't have a valid
Or
contract.
they're on something called marijuana, like you were saying. So,
And real estate
And
sales contracts must be in writing, like we talked about,
and
required by.
alcohol.
And that
Really?
Yes, ma'am.
Yeah,
So
alcohol.
if they're inebriated,
There
then
you
the contract
go.
doesn't stand?
if they're inebriated when they sign the contract.
Yep.
Yeah.
Yeah,
So
so
if you go, if I go and have Stefan fill out an offer form of buying this house for this much money, but when I go over, he's intoxicated and he signs that contract is voidable because he was not
Not in his right
illegal
mind.
of right mind when he signed it.
Oh, okay.
Because one of these elements is missing, it's not a valid contract. Any of these elements missing is not a valid
And with
contract.
legal purpose, that doesn't just, I mean, it's not just growing marijuana, that can also be like if you tried to buy my house in my neighborhood because you wanted to set up a coffee shop there, that's not, you can't legally do that because it is zoned as a residential area.
Right.
So it could also be
That's
for,
another good example.
yeah, more kind of unknowable legal reasons.
Zoning
you might
is
not
a
think
thing.
about, basically.
Unless you're in Houston, zoning's not a thing.
Really?
That's correct.
They have zero zoning.
I believe they are the
You'll walk 5
largest-
feet and
Yeah.
you're
A
like.
coffee shop next to a
Harvest
house,
stores.
next to an apartment, next to
Yeah.
this, next to that.
It's all over the place.
Hey, it's
I'm
really
about to go to
efficient.
Houston, buy
It is
a whole
really efficient.
neighborhood.
Really
There's
efficient.
a lot of businesses there.
You can do it. There's no zoning laws. Yeah, so everything must be in writing, as we talked about earlier. So if even one of these elements is missing, the contract is not valid. It's voidable.
Oh, my bad, dude. Click over there.
Okay, validity of contracts. A valid contract has all legal elements and is fully enforceable. So a valid contract would have, a valid contract would have all of those. A void contract lacks one or all of the elements and has no legal force or effect. So even, like I said, if even one of those was missing, it's void. Voidable contract has all legal elements and may be rescinded or disaffirmed. It's like if you were to, if a minor was to purchase property from you and then later on you found out that it was a minor, that contract would be voidable because they're not of the age to actually do it. Unenforceable, it has all the legal elements and is enforceable only between the parties. So it's not enforceable in a court of law, it's just enforceable between the two parties of the bilateral contract. Make sense? All right. And yeah, they might ask voidable. They might say a minor is trying to purchase a property.
Yeah.
Just say, if
It's a very common
anything
example,
minor,
yeah.
it's gonna be voidable.
Because if a minor tries to buy it, the contract is not void. It's not like it doesn't count, but the minor can void it at any point. But they can still go through with it and purchase the property. That's still legally possible. but they have the right to just back out whenever, and contract's voidable, I'm underage.
Yeah, and they don't have to pay anything
Yeah.
else.
I remember hearing something like this in my business blog.
That sounds like something they would do.
Yeah.
Okay, so for performance of a contract. Performance of a contract is completing your contractual duties. Like we said, there's elements of the contract that you have to complete for it to be executed, to get to executed. So if something goes wrong and something is not performed, then you can discharge the contract. You can terminate the contract. So these are going to be all different ways that a contract can be terminated. Assignment, you can assign interest to another party of the property. If you join Noble's Realty Group, he actually has a training on assignment. He does a training on that. And then novation,
What exactly is assignment?
it's where you can assign the interest you have in a property to somebody else. It's basically just
Like your assistant can go and take a look at it and do all the paperwork and everything, kind of?
Justin, help me out here.
Say what again?
You weren't even listening.
You're in class and you're playing around.
Are you
No,
playing?
I had it
Playing
agent
Candy
message me.
Crush.
You're playing Candy Crush back there.
He's playing Death Worm or something.
What was that? You're asking about assignment.
Assignment, yeah, it's
Yeah.
it's where you assign like.
So assignment is this, okay? Say for example that your house is for sale. I come to you and I say, I'm gonna give you, somehow I talk you down, like you had it listed at 200, and I'm like, I get you down to 100.
Okay.
You sign the contract. I have a contract. But I don't have $100,000. I just got you in contract here. So then I say, you know what? I know Travis has a lot of money, and so I'm gonna go to Travis, but I'm not gonna sell it to Travis for $100,000. I wanna make some money. So I say, Travis, I got a contract here. This lady has a house for sale, and I'm selling it for $150. But I'm not going to show him the contract that me and you signed. I'm just going to say I got a deal for $150, and he says, "Man, that house is worth $200. That's a steal." So he goes over, and I had him sign a assignment. What I've done was I've assigned the ownership, my interest in this contract, to Travis. So in that situation, when we close, what ends up happening is I am going to end up, I have to fill out some paperwork, but he's going to fill out paperwork. You're going to sign, all of us going to do the stuff. But when it's all said and done, he's going to get title. You're going to get your 100,000 or 100. No, it'll be 100 for you, 50 for me, and then he gets the property. And so in that situation is, I walk away with $50,000, didn't do anything but an assignment, and he gets the property, you get your 100,000, and we all walk away.
Just like a glorified middleman.
You got it.
Ah,
You got
I
it.
don't want to be an assignmenter.
And I'll tell you, well, no,
Glorified middleman.
and here's what I'll tell you to look up. When you go home, look up real estate wholesaling. That's what it's called.
Oh, it's wholesaling.
Yeah.
That was a
Wholesaling.
wholesale. That
Wholesaling,
makes
yeah.
sense.
Can you spell that?
So spell hoe,
Hoe?
WHOLE,
Yeah, like
and then
wholesale.
sales.
Okay.
Got
I
it?
heard something else.
Not HOLE.
Yeah.
Yeah.
And then
What's that
novation.
accent?
Novation is just where there's no longer a contract to do it. Like if the house were to burn down or something like that, or you can't purchase a burned down property, so that would terminate the contract. Or if the other party breaches the contract and there's a statute of limitations, there's a certain time period to where you can make a complaint on that. Like if someone were to breach contract, there's a certain period of time that you can sue. After that time, you can't come after them for it.
So who could breach the contract? Who would be breaching the contract in this situation?
Well, honestly, either could, but normally it would be the buyer. Or, I mean the seller, sorry, the seller, right?
Yeah.
The seller.
I mean, it kind of depends, because like, one example that both could happen is if we have a closing date set for, let's say, the 8th, for tomorrow. And by 5 p.m. tomorrow, the seller never came in and signed their side of the closing. They breached contract because in the contract it says by the 8th, buyer before the 8th of April, they have to close on the property. And if they didn't come in, they breached contract. But the buyer could do the same thing. The seller could go in and the buyer could not.
And I actually had a situation like that with my favorite client right now. We had a breach of contract, but it was the other party, the sellers, that breached the contract. They didn't give us any information. They didn't tell us anything. And then we were going, with the day of closing, we didn't have what we needed to close. So they breached.
Actually were content with something and couldn't get it. Oh, dang.
Yeah.
He wanted that house too. I feel bad for him because we could have got it to him, but the man that was selling that house was going through a divorce, and it was a mess. And he didn't know how much he owed on the house before he even put it up to sell. I know.
Call away.
And that's also part of a real estate agent's job is to make sure that they need to know the payoff.
So you're supposed to know his payoff.
So
his agent's supposed to know
right
what he's supposed to. Yeah.
So we were in a contract for $293, but he owes $314,000.
Oh, good.
So
with the
and we wanted to try and make up the difference, and my buyer was willing to dish out the extra money to get it closed. They wouldn't work with us, so we had to terminate the contract. And he said he was going to sue them if he could, but I don't. I'm going to stay far away from that. I don't want to get anywhere near that. So yes, statute of limitations is just a certain time period that you can sue or make a complaint on some action.
Yeah, for real estate stuff, it's 4 years, basically.
4 years.
Oh my God, how do y'all do it without getting stressed out? I'm just hearing I'm stressed out.
It's pretty chill.
It's actually not bad.
It's really,
People aren't as bad as some of them.
Up to 4 years usually?
Yeah,
Yeah,
usually the statute
4
of
years.
limitation is 4 years. So you have 4 years for somebody to file a complaint, or to sue, basically. Which is why I know for us, everything we have a software we use to file all of our documents and everything like that.
Yep.
And what happens is if I file something today on April 7th of 2025, it disappears.
Yep, it's just gone.
It's gone. Because one thing that can happen is if somebody can go through and find they're looking for something, once they have access to it, they're allowed to go through everything that's on there. So if they go through everything that's on there and they find a transaction I did in 2012 that I had some stuff that I did not know what I was doing, that can still technically come up because it's in a thing they were allowed to get into or whatever. So what happens is after 4 years, all the stuff that we have, it's on a 4-year cycle where 4 years it disappears. That way, just in case something was wrong about it, there's no evidence.
I mean, you yourself can keep the forms if you want, but
we don't keep them in like the company file.
right.
Yeah.
But after 4 years, you might as well just chunk it.
Yeah.
Okay, some more reasons for termination. Partial performance. That's where you only partially do what you were supposed to do on the contract.
Pay half the money.
Yes. And at that point, you can
Sell half
terminate.
the house. Yeah.
Substantial performance. This is a weird one. It's where you do the majority of the work, but not all. Probably do 95%. And so it wasn't fulfilled, you can terminate.
And that'd be a situation of like if I was under contract to sell that house that had the wasp coming, and let's say in the contract they wanted us to get rid of the wasp nest, and by the time closing came around we didn't.
Y'all got rid of the wasp, but not the honey.
Not the honey. Yeah, exactly. In that situation, we would have breached contract, and because we had substantial performance, we were going to sell the house. We did all the other things they asked us to do in the process of leading up to the closing, but we didn't do everything. And so that would be a situation of like partial or substantial performance.
Right. Okay, another one, impossibility of performance. Like if the house is in a sinkhole and it's gone, or it burns down, you terminate the contract because you have no house to buy.
Or if wasp honey.
If there's wasp money, yeah.
I'm sure that will sell for a lot on the black market.
Yeah.
It's probably the rarest honey in the world.
I thought about naming my real estate group, Wasp County Realty, just to keep it going, just to.
It's already in our minds.
We've honestly talked about writing a book about all the things that we've all gone through. It's like funny stuff.
I've only been doing this 2 years and I've read it.
I have a book.
Yeah. Some crazy people.
I started in July and I have a book.
Yeah. You got more weird ones than I got.
Yeah.
Mutual agreement of the parties, of course, they both decide they want to terminate, they can terminate. Operation of law, that's if, like we went to earlier, if I were to buy the house to grow marijuana, if it's illegal, but then it becomes legal, I might be required to purchase the property under the contract. But since it is illegal in the state of Texas, you can terminate the contract because of that. Or rescission. And rescission, that's just where you rescind the contract.
That's usually before everybody's signed and
Yeah.
Yeah. So if you're asking for $315,000 for your house and I offer you $317, and then before I get it back or before you send it title saying that everybody signed it, we're good, I can just take. We're not doing that. I take it back. I rescind that contract.
Yeah. So you can just rescind it. All right, so those are all the ways that a contract can be terminated. Does anyone have any questions? We good online? How we doing, guys? Thumbs up, awesome. All right. Contracts used in the real estate business. Now we're getting into the fun stuff.
Yeah.
There can be a listing agreement and buyer agency agreement. And I believe we go into more detail a little later.
All of these will be in the next class too. So.
Yeah, we do. Okay. So there can be a listing agreement that's going to be between the broker and the seller. Buyer agency agreement that's going to be between the broker and the buyer. Real estate sales contracts, that's the number one pretty much. 90% of your transactions are probably going to be real estate sales contracts. Options agreements. That's where you actually exercise the right to have an option period. And an option period is just the time period that you pay for that gives you, like, say, 10 days that you can back out of the contract for any reason. And that would be considered the option period. And escrow agreements, that's going to be between the seller and the buyer, not between, no brokerage is involved in that one. Leases, who's that going to be for? Who's that between?
So the tenant and landlord.
You got it. Land contracts or contracts for deeds, that's going to be between the seller and buyer. And an exchange agreement, that's also seller and buyer.
What exactly is an escrow agreement?
An escrow agreement, it's an agreement, it's basically, how can I word this? It's a
Big question.
It's an interesting.
Yeah.
An escrow agreement is basically, I'm gonna need Justin for that one, honestly. Hey, Justin.
I'm sorry, yes.
I feel like
take
it's at the
the
tip
ball.
of my tongue, but if you would like to just remind me of the smallest thing, it would just like come to me.
An escrow agreement.
Uh-huh.
What is that exactly?
I mean, that's where you're putting that earnest money into an escrow account. Now, there's two different ways. In title, when you're doing closing, you're in the process of a transaction, there's an escrow account to hold the earnest money and all of that.
Correct.
But then also the bank, after you finish up, you're going to have escrow being held as well for payments for taxes, insurance, and all of that.
Oh, okay.
So that's what that's coming into.
So
Okay.
escrow is just another word for saying kind of like a reserve.
It's a holding account.
Yeah, like a trust account sort of?
Yep.
Okay, gotcha.
And can I be the same as like with title, how you have an escrow agent, it'll be held.
That escrow agent's responsible for the monies that are being held.
Yeah, I have.
So when I send in my earnest money, my option money to buy a property over here, I'm not giving it to the seller, I'm giving it to an escrow agent at a title company who will hold all that stuff, and they're responsible for holding that stuff for when closing comes around, basically.
Gotcha.
And that's between seller and buyer. That's probably why I haven't seen it. Have you ever done an escrow, Justin?
Huh?
Have you ever done an escrow agreement? That's between seller and buyer, though, right? So
I mean, that's where it's not as a broker, that's in between the two individuals, to the parties. We pretty much stay out of that kind of stuff. The broker, the agents, we stay out of that.
Yeah.
All right. Listing agreements, now go into a little bit more detail. It's an employment contract that appoints a brokerage firm as an owner's special agent for the specific purpose of finding a buyer who is ready, willing, and able. That's key right there, ready, willing, and able. You will likely see that on the test as well. And that's going to be between the broker and the seller. And just remember, ready, willing, and able. If I bring a ready, willing, and able buyer to a seller, I've done my job. That's what you do when you're doing a buyer's. Oops. When you're doing a buyer's.
Yeah, and then you're supposed to bring a ready, willing, and able buyer, and the reason for that is that covers us in the situation of if I bring a ready, willing, and able buyer, but then they go through inspection and the house is falling apart and they decide to back out, they can't get onto us for not doing our job, not bringing anybody. We did.
We brought somebody.
We brought somebody who was ready, willing, and able. It's not our fault that we did not realize that the whole house was full of termites or something like that. So that just kind of covers us from the seller getting on us for not doing our part. And then also the reason for this is so this holds us accountable for putting everything, putting stuff on the listing services and to actually put signs out to market the property and to try to bring those people.
So if the contract falls through and I
Yes, you again.
I got a question.
yes, sir, Mr. Problem Child.
So let me get this right. So what if, Mr. Grossman, you are selling your house and I bring Sheldon to you, okay? And she's ready, willing, and able.
Right.
She's ready to buy, she's willing to buy, and she has the money to buy.
Right.
And then we find out that you actually owe more than what you owe on your mortgage than what we have in the contract.
I know all about that.
So then the buyer can either agree to pay it off, or my idea would be that they would pay the difference. So the buyer would pay what they said they were agreeing to, and the seller would have to pay the difference.
Mr. Grossman, help us out here.
So if I were to bring a ready, willing, and able buyer, even if the contract was to fall apart,
Well, she's asking how do you solve that? So I brought Sheldon to you.
yeah,
You owe, say, $15,000 more
yeah,
than what we have in contract.
yeah.
She's saying what could be done to resolve that? Could the buyer pay the difference?
The buyer could pay the difference. You could,
Could the seller pay the difference?
the seller could pay the difference. Anyone, as long as it's agreed upon, even if it doesn't even have to be money. Say I'll leave the fridge for me, and that'll help get us closer to that. Then, like, if I'm going to pay $2,000 to get the fridge from you, and that goes on the contract, that $2,000 will go towards that. So it could be buyer or seller on that. Does that answer it?
Now, am I entitled to a commission?
You brought a ready, willing, and able buyer. Even if it falls apart, you are entitled to a commission.
So you get commission on the amount that they owe on the house?
On the sale price,
Contract.
the contract price.
Always your contract. Because that's the written agreement.
Remember I was telling you earlier that we were in the for $293 and he owed
$314?
$314. We tried to get him to pay the difference. He said he had $12,000. Didn't have the $12,000 or didn't show us that he had $12,000, so it all fell apart.
You mean people lie?
Oh, they lied. Or they just don't check their stuff before they put their stuff on the market.
Right?
They just throw that thing on the market.
One thing I always like to say is that I would never say that clients are dumb, but clients are people, and people are dumb.
I found
So,
Truer words. Truer words never spoken.
yeah.
I mean, you literally get your mortgage statement in the mail every month.
This gentleman's excuse was, well, I went through a divorce and my wife did all the finances, and so I have the house and I don't know.
That's why your wife is leaving you.
That's none of my business. But it certainly was a interesting transaction.
No.
So if you want to sell your house, you're going to want to get a listing agreement with a brokerage. All right, so now we're going to types of listings. The exclusive right to sell. This is where.
Hold on. Wyatt said he wants to tell us what that's about. We talked about that earlier.
Go
See if
for
he
it, Wyatt.
remembers.
Go for it.
Who's it between?
The right to sell?
Uh-huh.
Exclusive right to sell.
I remember this
You got it. You got it.
I remember, I want to see if you
one.
I know this game. I used to play this game a lot.
The right to sell, that was between.
Think about it. Exclusive right
Yeah,
to
the
sell.
seller,
So
the
who?
seller
Uh-huh.
and buyer.
No.
Because I thought it was like
Who's
this,
selling?
that one.
Who's
Who's
selling?
selling the
Who's selling the
Who
property?
are they getting to sell the property?
Oh, the agent, right? Or the brokerage.
Yeah.
Okay.
There you go.
That was the one using earlier.
Yeah.
I thought it was the right to sell. It was like between the buyer and seller. So like it was like the 10-day.
The option.
Yeah, the
Yeah,
option.
yeah.
That's what I was thinking.
Every time you're wrong, Wyatt, she gets an extra day to go shopping with your credit card. So just let you know.
Hey, that wasn't expressed by me at all.
Oh, well, we got an implied contract.
Yeah.
So an exclusive right to sell, the brokerage gets paid if the property sells regardless of who brings the buyer. And this is what a lot of brokerages would
Like
use.
95% of contracts you'll get will be exclusive right to sell.
And that's what you want, because
Yeah.
you're gonna get paid regardless.
Yeah.
And it's gonna make the broker do the maximum effort and the maximum protection. Because they're gonna get a paycheck, they're gonna work for it. And we'll talk more about an open listing later. That is, you're probably not gonna wanna work for it, because you might not get a paycheck. But this
If I
one,
know that I'm getting paid, I'm gonna work.
I'm gonna work.
Yeah.
So, and that's, some brokerages won't even let you consider anything else. They'll say exclusive right to sell or nothing.
I know.
And that's gonna be a bilateral agreement as well.
And what that helps is how we were talking about everybody putting a sign out in your front yard.
Mhm.
It stops the, if I put a sign out, if I have an exclusive right to sell listing with you, and I go put a sign out front, nobody else can, like, that is my property to sell, or the brokerage's property to sell, nobody else can come put their signs out. But what that also saves is if, you're friends with somebody else and they come to buy the property, like you just know a friend who's like, oh, actually, I was looking for a place over there, my mom's looking, we'll just bring her over, and you have a friend that's gonna do it, I still get my paycheck, because even though you brought a buyer, I still have to go through the process of doing contracts and doing all that sort of stuff. And so that saves us from listing a property, going on the market for however long, and then suddenly they're like, oh yeah, I'm good, I sold it. Like, it's gone, I sold it to a friend. It's like, that's not, you can't, that's not how that works. I still need my commission.
I still
That-
get,
that
you still
happens,
owe
yeah.
commission. At that point, you would sue for commission.
Yeah, I sue for commission.
Because you still owe it.
Oh, what's that?
Huh?
You sue for commission?
Well, the
Oh,
brokerage,
the
There
broker
you
would
go.
sue for commission, and I would ask permission
There you go.
before we did
I would
that.
sue on behalf of the brokerage.
I would sue, yeah.
The broker would turn around and sue, because remember, it's the broker who makes that decision. The reason I jumped that one, there will be questions on that.
Yeah.
It'll ask who can sue for commission. Sales agents never can.
Never can.
Has to be the broker.
Has to be a broker.
And
And you might want to write that down.
One thing that helps me think about it too is that I never get paid commission. In a way, the brokerage always gets the 3% that I'm entitled to on the contract. I'm not entitled to that. And even though I have an 80-20 split with Justin, it's not like on the contract it states that when payout goes, I get 80% of that and Justin gets 20. It's when payout comes out, 3% of the sales price goes to Justin, and then Justin pays me 80% of that.
He'll break the check.
And so basically the commission always goes to the person on the contract, and the person on the contract is always the brokerage.
I forgot to tell you, by the way, she inserted a new clause in that 80% goes to her shopping spree. I forgot to tell you.
Why is she going shopping?
She's gonna come back with,
She changed it today,
I was
so.
going,
she's gonna come back wearing Gucci and Prada,
Already
all the
know.
good stuff, right?
right?
But keep going, Travis.
But so that helps me think about like who has the right to sue. Well, it's not me because technically I don't get the money. the brokerage that gets the money,
Yeah.
and then they pay me
And they
out.
pay the agent.
Yeah, and so it's actually their right to get the commission in the first place. So
So
that kind of
agent
helps me kind
cannot
of separate
sue.
that.
Agent can never sue for a commission.
On that note, do you ever have anybody that will say, well, I don't wanna pay you 3%?
Yeah, but you're likely not gonna get very many agents coming to show the property if you're selling.
If you're on the, so like we have a listing service, we can go through and look at all the property. That's how we do a lot of searches and stuff like that.
Right. multiple
And on them, it'll show that like the selling agent gets 3% and the buying agent gets
We
3%.
actually talked about
And what usually happens is actually the seller is paying the we'll talk about this in the promulgated form, so it's not all in the contract, but basically they pay their selling agent 6% commission. And then we sign up, like basically the brokerage signs a form in the contract that the selling agent will then pay the buying agent 3%. So they'll pay them half that. And that's where you get the 3 and 3 split from.
Yeah, and you can
But
expect
all the
it.
money comes from the seller. So the buyer is not paying, if it's $300,000, they're not paying $300,000 plus $9,000 for 3%. They're not. That's not how it works. They're paying their money, and then this other percent's going from here. So that the buyer never has to pay the commission. It's always the seller that does so. But you will see on the listing service sometimes where if you scroll down, it will say like, well, actually the seller's agent gets 4% and the buyer's agent gets 2%, or the seller's agent only gets 2% and the buyer's agent gets 1%, because the person they listed the thing with doesn't want to pay 6%, they only want to pay 3% or whatever. But in that situation, if I'm looking for a bunch of properties for somebody, I'll send it to them, but I'm not going to put a whole lot of effort into trying to push to go look at this property that I know I'm going to make $40 on if we actually go through the contract. When there's another one they like just as much or more, that'll give me a few thousand. Like it's, and so that's why 6% is a kind of baseline amount that you'll see again 98% of the time, and that 3% for the buyer's agent 98% of the time. That's what it is, because that's the norm, and people know if you have an agent here that's selling your property, if you don't pay them 6%, again, like how we were saying, the maximum protection, because the broker will get the maximum effort because they know they're getting paid. If they know they're only getting paid 1%, they're not going to put that much effort. So it's kind of, that's kind of the known thing, is that 6 or 3% for each one, just because that's how it's used. So.
And then you'll get some agents that'll say, "Oh, just give up your commission. We'll get the deal done." Never give up your commission. You do not have that power. That is your broker's power.
And like for example, that house that we were dealing with the boss plan, all that stuff that came through at the last moment, they said in that email that we needed to take this out, replace this thing, do this with the loss money, do this and that, or pay them $3,000 in consideration to fix all that stuff themselves. Which was stuff that we had already fixed after their first inspection, or was stuff they just found the morning of. Like we knew that stuff wasn't there. And so the selling agent actually called me and said, hey, because I asked Jason, the buyer, I was like, or the seller, I was like, you gonna give him $3,000? And he was like, no, if they're gonna breach contract by not going to closing in 15 minutes, then we'll just move on to the next meeting. I was like, sounds good to me. So I called the selling agent and went, or the buying agent, and went, we're not paying that $3,000. He was like, well, okay, how about then if I'll give up $1,000 of my commission, if you want to give up $1,000 of your commission, that'll be $2,000. That way the buyer will be happy, the seller doesn't have to pay anything, and we can just get this deal over with. And I was like, nah, I'm not doing that. And again, that's not even my call. I would have to talk to Justin about that, and Justin would go, no.
Like, you give up your commission. No, you give up your commission. I'm not giving up my commission.
Yeah, and so I don't know what happened with all that, but like as far as I know, that guy gave $2,000 of his commission to make. Like I have no idea what happened with that, but that's something that could have happened just to keep the buyer happy, so they buy the property, so the deal would just be done.
Oh, that was another thing too with that the property that we were in the contract for $293 and he owed more. I lost my train of thought.
Did they ask you to pay for it?
What?
Did they ask you to pay for it?
Oh yeah. They asked. We actually offered to give them our commission to help get the thing closed, just because I've shown this guy so many houses. We just wanted to get the deal done. So you can offer to if you need to, but
Yeah.
you're not going to pay.
Can the sales agent do that, or do they need broker approval?
They do broker approval.
So Travis can't just go out today and say, you know what, I'll list everybody's houses for free.
Just always remember broker approval. I mean, it could be for anything. You need broker approval.
Because again, I'm not the one who gets the money.
I'm not the
stuff.
one.
So if I go out and sell a house for free, yes, I'm, scamming myself out of money that I should get, but I'm also scamming Justin out of money because he's the one that should get the check first. That says, here's how much your commission is. When he gets it, it says 0. He's gonna be real upset.
Especially if I'm carrying now a huge liability that the lawsuit could come back if something went wrong.
Yeah.
And I have no money. So.
And he's got expenses to pay as a business.
Yeah.
All right, we gotta keep moving. We're in a little. We got quite a bit more to cover. Exclusive agency. That's where the broker gets paid if the property sells, unless the owner finds a buyer. And you will see that sometimes. Sometimes people will do that, but in reality, you're gonna want that one. All right, some more types of listings. This is the open listing that we were talking about. Basically, any brokerage can market that property and sell it, but the only brokerage who gets paid is the one who finds the buyer. And sometimes you'll see, what?
Oh, so the price everyone's doing it for free until you make the sell?
Until, yeah, I mean, you're not guaranteed a paycheck at all.
Okay.
It could happen, any brokerage can take it. And sometimes you'll get it if you bring a buyer to the seller and the seller will behind your back try and get that buyer's number and then cut you out of the deal. That can happen too in an open listing. And I think we have a couple open listings in College Station right now, I believe, but they're pretty rare.
Yeah.
A seller can sign open agreements with more than one brokerage or firm, so an all brokerages can be it. It's a unilateral agreement because it's just the seller. Even the seller has the right to commission if they make the sale. Sell to a buyer automatically terminates all open listings with or without notice. They don't even have to give you notice before they terminate. Make sense? Questions? Online's good?
We good online?
All right. Special listing provisions. This is a multiple listing clause. Allows the broker to list the property on the multiple listing service or MLS. This is how you will see it. This is the terminology that we use. You won't hear me say multiple listing service. I will say MLS. And it's just a collection, like Justin was saying, of brokers. We can all see our listings. We can all see each other's listings and everything like that. The listing brokerage and broker represent the seller. And the buyer's brokerage and broker represent the buyer. All right. More special listings. There's a net listing. Yeah, that's where the brokerage receives a commission on all money above agreed minimum price. So let's say that someone's house is worth $300,000, but they look up their estimate online and they say that it's only for $200,000. And so we go into a net listing agreement where if she agrees that if I can get you the price of $200,000, then anything above that comes to me. I get it. And it's illegal in Texas because people were taking advantage of people like telling them their house is worth this, and then what?
Your house is worth.
You said it's illegal. It's not really illegal.
It's illegal or not recommended in most states.
Right.
In order to protect the sellers, because they may not be aware of the true market values, you could be lying to them, like I said, and walk away with $100,000 because you sold it for $300,000 when that she agreed. Yeah, if you sold it for $200,000, I'll give you everything about it. You walk away with $100,000.
So does DTPA not protect that?
Well, it depends on the situation, but in Texas, you can't really do it. You have to provide the seller with a CMA, like a comparative market analysis that shows them the price that their house is actually worth.
It's not illegal to have one in Texas, but the only way to get it is like it says here, if the seller requires it. So you can't talk them into it. They have to require it. And they also have to have an understanding of the current market values of the property. That way, again, they know their house is worth $315 or around that, so they'll set it at $315. You can't go in there and talk them into your house is only worth $250, because if they know the market value, they know that's not right.
Right.
But what if they also by getting
Yeah, well, that's the same sort of thing. But again, you'll get different appraisals are opinions, so it's kind of you get that different sort of. If we all did an appraisal of the same property, we might all come up with different amounts. And so just because I did an appraisal and found that it's $300,000, he might do one and find that it's $265,000. And so, it's like, I mean, that's an extreme case, but that's why usually they have to be familiar with the market values, and that's also why they have to require it off the bat. Is if they know it's worth $320 and they require that you do it for $320, then you can. But for the most part, it's not recommended, because by that point, they know it's $320. You're probably selling it for $315 or $320, so you're not making anything. So
to answer your question, Ms. Shelton, yes, in that situation, if you were to say, if that situation where it's $200,000 and I made the $100,000 more, that person could come back and sue you for deceptive trade practices. And if they did, they could sue up to 3 times damages. In other words, I would owe $300,000. So it's just not worth it.
Yeah.
Just be upfront. Don't lie. Don't mislead.
And this is one of those things, like, this is a thing
It's
you can
common
do.
sense, right?
Don't. That's kind of just like, again, always keep exclusive right to sell. There's really no other reason to not do that.
Pretty much. So if the principal requires one, or they must be familiar with the current values, like we said.
Yeah. So you mean that I have a duty, guys, to put my client's interest before my own?
Yeah, that's what you should be doing.
What? I thought it was all about putting money in my pocket.
No,
we need to get
no, it does.
We need to put.
We need to get a new broker.
Dude, this one is broken.
I don't know what happened.
This broker is broken. Termination of listings. That's when the agreement's purpose is fulfilled, such as when ready, willing, and able buyer has been found. Like I said, ready, willing, and able. Key. When the agreement's term expires, that's another termination of a listing. If the property is destroyed or its use is changed by some outside force the owner's control, such as a zoning change, not in Houston, or condemnation by eminent domain. And I believe we go into eminent domain a little more. I don't know if it's in this class. It might be contract forms and addenda, but y'all will go over that. It's basically just the state's right to take your land for public use. All right.
What happens if there's a squatter in the house?
If there's a squatter in the house and
And nobody's been living on it, but somebody's trying to sell it.
the sad thing is, if the squatter's been living there for, is it 7 years, Justin?
It varies. So we're not going to go into that. We'll go into that later, but it varies based upon different time frames.
But yeah, they own the house if they've been in there for some amount of time.
They get there for some time and they pay the taxes on it. It's their property.
They own the house. No. If title of the property is transferred by operation of law, as in the case of an owner's bankruptcy or foreclosure. If the broker and the seller mutually agree to cancel the listing, then it's terminated. If either the broker or the seller dies or becomes incapacitated, if the salesperson dies or becomes incapacitated, the listing is still valid because the listings are under the broker, not the listing agent. So if the broker goes, it's gone. if you see past date, then the listing is gone. But if the salesperson does, it's still there. It's bound with the broker. You about to ask something, Justin?
He has a weird face.
You got a face going on there.
You're telling me that if Wyatt drives me to where I'm now becoming incompetent, that you lose everything?
Really?
Wyatt, don't drive me crazy.
I just always transfer ownership to somebody else.
I could myself, if I'm incompetent, then I'd have, another broker has to assume my road. Yes. That's one of the things about an independent broker. When you're not part of a national wide, that's one of the drawbacks is if you only have one broker and no other brokers, if that broker dies or becomes incapacitated, that whole firm is pretty much gone. Gone. Yeah. When COVID was full force, everybody away from me because I was like, they knew if something happened, the whole firm would just collapse. So I had to basically take very serious precautions to stay away because if something happens to me, that's it. It's like a queen in the ant pile. Once it's gone, it's gone.
Of course, you can always take your license to another firm.
Yes.
But, you know.
So we call Justin the Queen.
He's the office queen.
Yeah.
Y'all just keep
Nah, I hate God. I hate God in the time you leave I hate God.
Okay, buyer agency agreements. It's an employment contract that appoints a brokerage firm as a buyer's agent for the purpose of finding a suitable property for the buyer. And the parties are going to be the buyer, which we said was the principal. Remember, principal means client or buyer or seller, to be either. And broker, and it's between a broker and an agent. Broker agent. Leasing real estate. Leasing is a little bit different. A lease is a contract between the owner of real estate, the lessor, and a tenant, the lessee. A lease is a conveyance of a possession of real estate. Remember we talked a bundle of rights? The owner has many of the other rights, but he's transferring the possession, the right to possess the property to the tenant. And it's a contract to pay rent and assume other obligations, such as if he has to do maintenance. Some landlords will pay for maintenance, some won't. So you have to perform your obligations of whatever they might be. The statute of frauds in most cases requires lease agreements for more than 1 year to be in writing to be enforceable. Remember I said anything 1 year or lower, you don't have to have it in writing. That's the only exception to the statute of limitations. Any questions? Got it? Moving on. Leasehold estates. That's the tenant's right to possess real estate for the term of the lease is called a leasehold estate. And that it would be a set term for a leasehold estate. And if you were to buy or own home, you would have what's called a freehold estate because it's free and clear. Leasehold just means there's it's a form of ownership, but it's not, you know, it's not like a yeah.
Only home would be what hold?
Do what?
When you said leasehold, you said if you owned it, it would be a what?
It would be a freehold estate. Tenancy for years or estate for years. These are different types of leasehold estates that you can have. That one is for years is for any definite period. So it could just keep going. An estate for period is periodic tenancy. There's an indefinite term and it automatically renews. So that one just keeps going. The term ends, boom, it already starts over again. Tenancy at will, it's an indefinite term and possession only with the landlord's consent. An estate at sufferance or a tenancy at sufferance is the reason the tenancies are in there, that's probably how you'll see it on your test. They won't say estate for years, they'll say tenancy for years. So tenancy at sufferance is the tenant's previous lawful possession continued without the landlord's consent. So he continued to occupy the property past his lease without the consent of the landlord. Lease agreements. These are going to be the requirements that you need to have a valid lease. The capacity of contract. They need to have the capacity and know-how to know what they're doing. Legal objective. Like I said, if I'm going to buy the property to grow marijuana, it's not legal objective. Offer and acceptance. The buyer will offer, and the seller can either accept, reject, or counter. And then consideration. And remember, that could be anything. Likely going to be money for tenant for this, but for leasing, but it could be anything. If I was going to lease something for my dad, I'd just say, hey, I'll clean your car or something every. How about that? Can I live here for a while? It could be anything. And they're going to have the right to possess and use the premises for the term of the lease. And there has to be a security deposit that's put in, and that's in case the tenant destroys the home or something like that. The landlord can take that money in. Yes, sir.
Can I apply my security deposit to my last month's rent?
You can apply your security. You cannot. Really? I don't even know that.
Security deposits cannot be applied to last month's rent because what is the purpose of security deposit?
It's in case they. Yeah, it's okay. Yeah, that makes more sense.
Cause they tell people.
That is
Yeah.
correct.
So wait till the last month, and then you care of everything.
But after the lease is done and there's no problems, the security deposit will return to the buyer.
Now, you said something earlier about something about I don't have to write things in writing, agreement.
Only if the lease is for 1 year or less.
So if I'm gonna rent a property for 1 year from Miss Davenport, you're telling me I can just go shake her hand and that's it?
If she's okay with it and you're okay with it, then yeah.
What if me and Miss Davenport decide I'm gonna stay a year and just 1 day? I don't need it in writing, right?
A year and 1 day?
Yeah.
Oh, you need it in writing
Why don't I need it in writing?
because it's over a year.
Because
Even
it's
if
over a year.
Even if it's 1 day, it's over a year.
There you go.
Yeah, so
And that's, they will bring that up on the test. The term is over a year, not for a year or over. That is something they will try to trick you on. Is they might say something like, if I'm doing this for a year, do I need that? And it seems like yes, because you think, oh, if it's less than a year, you don't. But it's actually a year or less, you don't.
yeah, a year
Yeah.
or
So let's say it's a day over, that's.
Yeah,
That's-
when it comes up.
And what's that legal term that says that? Statute of what?
Statute of frauds. So you gotta do that. All right, moving on. Improvements. These are first yeah, I think these are more for a valid lease. Any improvements done to the property, accessibility for people that, handicapped people, needs to be accessible sometimes. Maintenance of the premises. Like I said, either the tenant or the landlord will probably take care of that. Destruction of premises. What is that one there for, Dustin?
I don't know, I'm a student.
Oh, you're a student.
The security deposit.
Security deposit will cover that. Hopefully,
Yeah, right.
sometimes you could do more damage than the security deposit is worth.
Ooh, question.
Yes, sir.
What if we get upset because we're renting from Wyatt and he never gave us that credit card, and so I flushed concrete down his toilet, but I only gave a $500 security deposit. I'm safe, right?
No.
Somebody going to jail.
No, you're not. Somebody going to jail. Now, somebody's gonna.
Somebody gonna get. I'm gonna fight somebody. That's right.
You just might wake up and find yourself in
DDR.
couple hundred thousand in debt.
Right.
You know?
But yeah, so the reason I brought that in there is that yes, if there are sometimes people will get upset, especially right now. What is currently going on right now?
Every day.
Class.
Rona.
Well, Rona, but what's Corona's causing what though? Eviction what?
Yeah,
You can't
Flood
be evicted.
moratorium, which means you cannot evict a tenant,
Yeah,
even for non-payment.
yeah.
So what's going to eventually happen? That moratorium is going to do what? It's going to expire.
And
Now, when it expires, how much does Wyatt, since he's not paid you rent, how much does he owe you? A lot of money, and that's due when?
The date is,
immediately.
The day it ends. All right, you go, boom,
It is gonna be.
and you're going to tell him you owe me $15,000. Where's my check?
Where's my check?
And Wyatt's going to say, I went and partied it out at Northgate and I ain't got none. And you're going to say, then out of my house. And what's Wyatt going to do?
Break all the
Concrete.
mirrors.
Concrete, toilet, flush, and leave.
And just so you know, that will completely destroy the house, pretty much.
That'll destroy your plumbing.
Concrete in the toilet.
people actually do that.
Oh yeah.
Oh, it's happening.
Oh yeah. Oh yes.
Oh yeah.
That's some real.
Oh, it gets worse. I've dealt with foreclosed properties where they will go through and they will put nails. They will take nails and they'll throw it all around the driveway and then put grass over it. So when people drive in, it pops all 4 tires. You'll walk around and you'll fall in booby traps.
Oh my god.
People are crazy.
Oh my goodness, right?
Tenants are crazy. Crazy.
Crazy people.
Crazy. Let me just say it one more time. Crazy.
If you can tell,
From experience.
Sheldon's never had any problems, just to let y'all know. Y'all
Never. It's been the most smooth sailing thing I've ever done in my life. I mean, jump right in.
But yes, you will run into it. And then like I said, okay, so continuing with that. So now Wyatt has flushed concrete down your toilet. He paid you, say, a month's rent. All right, he paid you 1 month's rent. Is 1 month's rent going to fix the plumbing issue?
No.
No. So it's probably going to cost $20, $30, $40, $50,000. Who knows?
Might as well just tear the whole thing down.
Well,
Right?
Well, but in that situation is you just got a guy that is got no job, unemployed, has no money, destroyed your house, and all you got is 1 month's rent to fix Wyatt's issue.
And you can go after him.
What's going to now happen to her as the owner?
She's
Do
gonna
you-
go find him and knock out his teeth.
Then you go to jail.
In that situation, what happens? Guess what? She can now, Travis, you lent her the money. Have you stopped charging her mortgage on that property? And then when she now just has $50,000 in repairs and she can't rent it because he destroyed it, what are you gonna have to eventually do? Foreclose on it. Now what just happened to her credit?
Way down.
Destroyed. Because one stupid thing.
And
And then goes to tax sale.
And from what you
And he
said-
gets it for $300.
Yeah.
Back around.
And from what you said, if you want to go after him for money, it sounds like he doesn't have any. So
That's right.
good luck getting that money.
Can't go for that.
But y'all see kind of how this works? Like this whole process?
The tenant always wins.
And in that situation, because you're out, her credit's screwed.
Yeah.
You technically, especially if you were renting from her, she can't really mess with your credit. She can sue you and try to get a judgment. But if you ain't got no money, what you gonna get?
Nothing.
I've had to have those discussions with clients before. Let me tell you, they're not very fun discussions by any means. Okay, and imagine had I been her property manager, had I managed your property, and that happened, who's she gonna be upset at?
You.
Me, because I failed to do my job. You see what I'm saying? You see where lawsuits come in. You see why I don't touch property management?
Right.
Because it's a nightmare. For the pennies you make, it ain't worth it. It ain't worth it. Go ahead, Stephen. I'm sorry.
That's fine. Assignment and subleasing. We told you a little bit more about assignment earlier. And sublease is, Justin, help me out on a sublease.
Well, they should know this.
I got that down.
Should know
Is that a
this.
portion of the lease?
That's where you lease like a part of it, right?
No, it's, isn't it?
Oh, no, that's double.
Oh.
So 2 people are leasing one place.
Oh, yes. Okay.
No.
No, because that's a sandwich. That's a sandwich one.
Okay, seven.
Subleasing is getting like
This is-
This is one
lease.
She's telling.
Getting. Oh, I'm sorry.
Go ahead.
No, you're Sheldon. Go ahead, Sheldon. Go ahead. That's
Oh,
all.
okay. I'm thinking subleasing is if you are leasing and are trying to get out of your contract, you can find another party to lease in your place.
There
If
you
you're-
go.
She got it.
If I'm
There
under
you go.
contract till December to lease this property, but I don't wanna be there because I wanna move,
There
I can
you
find
go.
somebody else to lease it instead of
There.
me until December.
That is
Yeah.
correct.
Don't ever copy off of my test.
No,
You see
that
that on college like stories all the time.
Yeah.
Just subleasing.
If you go on like Facebook Marketplace in College Station, like
Yeah.
half of them are people trying to sell these places because they wanna move or whatever.
that's right. Now, does that sublease? So, Wyatt, say that you were wanting to sublease, and I want to take over your lease for you.
Mhm.
Can I just move in and just immediately just move on? Can I just, Travis? Can I do that? Can I just move in his spot and just make payments? What do I have to do?
It's another.
I have to do an entire process.
Yeah, it's
I
like a
have
whole
to go
contract. You gotta like do your whole leasing thing yourself.
exactly. I have to apply. I have to go in and get approved,
Yeah.
pay my application and all that
Mhm.
for it to be approved. I can't just move in. Now, a lot of tenants think, well, you just move out, I'll move in.
Yeah,
Don't work like that.
it's like a whole
Does
process.
not work like that. Question? Good? Y'all good? Go for it.
Last one, option. You can have options on where you want to live.
No. Options are basically in the situation is there can be certain options in regards to review or things to that nature. So for example, it's similar to an options, not contract, but you can go into some situations and go in and ask for certain amenities or certain things. If they cannot be put in a contingency bit there, then they do not have to agree to the amendment or to the agreement.
I see.
Okay.
Does that make sense?
Okay.
All right, now we're going to types of leases. The gross rent, or gross lease, that's where the tenant is going to pay a fixed rate, but the landlord is going to pay all expenses, and that's going to be like taxes, insurance, maintenance, and stuff like that. And then you have a net lease. That's where the tenant pays the base rent plus some of the expenses, but not all. It could be property taxes, insurance, maintenance, same thing. A percentage lease, that's more for commercial because it's where the rent is based on the percentage of the income of the property. So they say, oh, we want 10% of your profits and you can live here in exchange, stuff like that. That would be a percentage lease. A variable lease, that's rent increases or decreases at predetermined intervals. I have not personally seen one of those yet, but
That would be more like a escrow kind of, not escrow in a mortgage kind of situation where the taxes go up or down, then their rent would increase or decrease based off of that.
right.
So I'm gonna go in real quick and kind of hit the four, kind of explain them to you. So gross basically is kind of more of the, kind of like a rental, like your residence. You rent a property. You're gonna pay
$800 a month.
Yeah. I'm gonna pay $800 a month. Landlord pays for any expenses, like termites or like any stuff, they take care of it. I just pay my $800. Simple. Net is I'm gonna pay my $800, but I also am gonna pay a portion of the property taxes, the insurance, and the maintenance. You see that more like you're in my office building. In this deal, I pay base rent, but I also have to pay expenses, property taxes, insurance, maintenance, or any of those things that's included. So my rent may be $2,000, but I also got to pay maybe an extra $1,000 or whatever in extra stuff that's going to be added into that monthly. In a percentage, the rent's going to be based on the percentage of your income or sales. So if I'm a brand new business, I'm a baby business, and Ms. Davenport has a property and I can't afford her $1,500 a month, I may go to Ms. Davenport and say, well, Ms. Davenport, can I ask you a question? Can I do a 12-month lease, but I give you 10 to 20% of my profits, my income, so if I make sales, then she gets a lot of money. If I don't make sales, she gets no money. In that situation, it now has Miss Davenport trying to encourage traffic into my business so that I make more money, so she makes more money. So that's where your percentage comes in.
Right.
A variable is where another type of situation where I'm a brand new baby business, and different, just depends, where it basically increases over time. So I may say, I'm a brand new baby business and I'm just starting out. I want to end up, I don't have much money right now, but I'm hoping in 5 years I will. So they may say, okay, you know, Justin, you'll pay $500 a month for 5 years. But after $500 for 5 years, you're in that 5-year interval, we're going to jump it now to $2,000 to retroactively go back and make what we didn't make over that time. And then next thing you know, as you continue to grow, we'll jump it again. And then it goes to a certain level in that situation. Does that kind of break them down, make sense? So there's a lot of different things, and you got to know these because when you're, especially in commercial, you got to know this kind of stuff because, you know, in everyday residential, you're going to deal with gross. Maybe net, gross and net, most of the time gross. Okay. But when you're dealing with a new business, a brand new business, you need to know all types of these so that when you go talk to them, they may not have $2,000 a month, but they may be able to get, you know, little sales here and there or whatever, or maybe they could do some of the lawn maintenance or stuff in exchange for the rent, things like that. Everything is negotiable. Both parties just have to agree. Does that make sense? There you go.
All right, a ground lease. That's where you're going to rent unapproved property. Maybe you need the land to run cattle through, or maybe you want to go hunting out there.
These are very short term, right? Like 1 or 2 months, right?
No,
How long are they?
they didn't go for a very long time. It can go for,
Not indefinite.
it can go,
Gotta have a term.
it's going to have a term, but it can go for a very long time. Yeah. But yes, if you want to like maybe go hunting on someone's land or
What's the longest?
running
one you've seen,
cattle.
Justin?
50 years.
50 years is a long time.
Now, some people go longer. But it really just comes down to friends and things of that nature. Yeah, it really. I mean, let me tell you, the good old boys back in the redneck part, everything's done by handshake. But it's just you got to be careful because then you start running into, like you're saying, going and having squats. If I'm constantly, me and you, say our land's butted up next to each other, we take the fence down, and my cattle keep running over into your property, what could I eventually maybe try to argue? Well, all this part that she's been letting me use, she ain't using it, so that's mine. I want that property. So you see, when there's a dispute between me and you, what could happen? Go ahead, you got a question.
What would be the statute of limitations on that?
It really depends. And you got to also kind of look at all the laws. That's why I always tell people, don't just jump into squatter immediately because there are certain elements that have to be met. One of them being is that you got to pay taxes. Just because I have my cattle on your property does not mean that it's mine because I haven't paid the taxes on it.
I have an actual real life scenario for myself in that situation.
Uh-huh.
So I purchased my house from my brother, and the neighbor put up a fence, and they put it 5 feet into my property.
Encroaching.
And then I made them aware. I gave them a written notice, and I told them that we don't plan on selling the house soon, but whenever you have a chance, can you move the fence over your property? So we have been in that house for 5 years. Would that be approaching the end of that statute of limitations?
If you're getting into 5 years, you need to hurry up and get that moved quickly. Because 5 years is kind of getting to that point of squatter. Now, one thing is, have you been paying your taxes every year without, and nobody's paid anything that you know of on the taxes? Okay. In that situation, another thing in there is you have notified them in writing. So that notification in writing also kind of resets that statute. Because when you send it, it starts back from when you were telling him, you need to move this. So you're aware of it, and you're telling him, and he's not doing it. I would follow up and send another letter and be like, hey, we've talked about this, it's still not been moved. You know, I need this moved. Otherwise, you know, I may have to seek counsel and see what they say. Because otherwise, if that thing stays on your property, when you go to sell it, you may not be able to get title insurance.
Yeah.
And you may run into an issue of them trying to argue that there's squatters' rights. And then that could tie up your entire thing for God knows how long. You see what I'm saying?
Yeah.
So in that situation, that thing needs to be moved.
Yeah.
Now, some attorneys may tell you, go tear the damn thing yourself, just tear it down, because it's on your property.
Yeah.
So if it's on your property, it's just like if a tree is going in like some neighborhood, say Travis, say I live next door to him, and my driveway, his tree goes over my drive. I truthfully could cut that off, all those limbs that are on my side, because it's encroaching onto my property. So you can do that. However, I don't think it just common courtesy. If I went over and cut his stuff over there, do you think we're gonna have a good relationship? No.
Unless I hated that tree.
Yeah, unless you hated that tree.
The odds.
I hated that tree.
But in that situation, if I've notified Travis and I'm notifying him and he won't do nothing, then at that point you already have an issue. Just cut the thing down. But you need to kind of at least try, because that's what a judge is going to look at. Is, did you even try? Did you try? And if you show proof that I've tried multiple times and he didn't do nothing, I'll tear that sucker down.
Yeah.
But again, of course, consult an attorney. I always want to do that. So, but you want to be careful with those, because you don't want them coming back trying to say something like that.
Yeah.
Make sense?
Yeah.
All right.
Thank you.
Anytime.
All right, a sandwich lease. The original lease between the landlord and the tenant one, and then tenant one subleases to tenant two. So it's basically two tenants and the landlord sandwiched in the middle. An oil and gas lease, that's where the landowner allows for the exploration and production of oil and gas on the landowner's property in return for payment. So he says, yeah, you can drill on my land, but I want some of the money.
Is that a lot of that fracking stuff?
Fracking, well rigs, stuff like that. Okay, different ways that you can discharge or terminate a contract. When the contract terminates, when it expires, when the contract is done, the lease ends. If they both agree that the parties always, they both agree that then the lease is terminated. Operation of law. So if the guy goes bankrupt or something like that, that's one way that you can terminate a lease. Maybe I have something. Nope, there were no options. Potential buyer purchases the right to buy at a fixed price for a designated period of time. The purpose is that I promise to sell if you decide to buy. So it gives the buyer the option to purchase the house if he wants, but he's not obligated to actually purchase the house. And that would be an option lease. It's unilateral, binding only on the seller because the buyer has the option, like I said. And it becomes bilateral when the buyer exercises the option to purchase the property. So you can live in that property for a while, lease it out, if you like it. I decide I want to buy it. There you go. Now you have the option to, because you had an option contract. More on options. Parties, the owner is the optionor, and they will use words like mortgagor and mortgagee and stuff like that. It can get very confusing between the two. So owner, optionor, the buyer, person purchasing the property is the optionee.
Have you explained the difference to them about the OR and the EE?
I don't know, not in detail.
Okay. Put this down on y'all's notes. I just want y'all to do this real quick.
It's the same for,
Yeah, for all of them.
yeah,
So if you see, do you remember it, Travis?
I don't remember,
I don't want to let you do it if you did. If it's OR at the end, then put OR equals doing. Okay? EE at the end is receiving. Does that make sense? So the person doing the thing is the OR, the receiving end is the EE. Does that make sense? So the person that is doing, say, the quote unquote inspections, they're exercising their option right. Who would be doing the inspections?
Yeah, inspector.
Well, they would do, but who would, I'm sorry, that was a bad question. Who would be ordering the inspections? Who's asking for the inspections?
Inspectee.
No. The buyer. Because who benefits from the buyer or from the inspection? The buyer. So the individual in an inspection would end up in that particular situation would be wanting to get the benefit from it, which is going to be receiving the benefit of the inspection, which is the option E. They're receiving the benefit from the inspection. But who exactly is exercising the not to sell? Look up there at the top. Boom, right there under parties. What's it say? The owner, which is also the seller. So the seller has a right to sell their property, don't they? Okay? But because there's an option, they are not doing or selling their property. They have a right to do something, but they're exercising not to do it for the benefit of who? The potential buyer, which is the option E, who's receiving that benefit. Does that make sense? Honestly, because I know that's confusing.
But
Wyatt, do you understand?
no, I'm understanding.
Honestly? Okay, just making sure, because it can get very confusing. That's how you have to look at this, is you have to think, what are their legal rights? If you're selling your property, could you sell it to whoever you want? Yeah. But you chose not to sell it to anybody because Travis is came to you and asked for a 10-day time frame. So who's receiving the benefits? You or Travis?
And he gets
Right.
10 days.
Because he gets 10 days to
Yeah.
stop you from doing something. Yeah. Does that make sense? That's how that basically breaks down.
And the or E is the same thing, but in a lease, the lessor and the lessee, it's the same thing, where the lessee is the one receiving the lease, they're the one that's getting to live there and be the one who's benefiting from it. And the lessor is the one doing the lease, providing the lease.
You'll kind of see how this works. And what you will see OR and EE.
Yeah,
a lot.
there's like 6 or 7 different ways in mortgage or mortgagee that
Yes.
comes up, so. And I think there's even, I think in principles, there's a slide that literally is just.
You'll
all
see
those-
offer,
all those explained, so.
offeree, counterofferor.
Yeah.
It's a lot. It's a mess. Like they love their fancy words.
Yes.
And it's typically going to include a non-refundable option fee. If the buyer decides not to buy, the seller would have no recourse because it was only binding on the seller. The buyer did not have to purchase the property. They just had the option to. The seller would keep the option fee in that case.
I've learned this over time. If you want to stop somebody from doing something they have a right to, for example, Miss Davenport, I hear, is a party animal. Okay, just FYI.
Where's my invite?
She's a party animal. So, and I hear she likes to throw parties starting around 1 in the morning. So, and party until 4 a.m. is what I hear. So she has a right to do that because that's her house. Okay. But I heard that if you go over there and possibly give her some money, she'd stop doing it. So if I happen to live next door, could I possibly, Wyatt, go over to her and say, hey, Miss Davenport, I'll give you $10,000 if you never throw another party while I live here? Could I do that?
You could, yeah.
And could she accept it and not basically be able to throw parties between 1 and 4 a.m.?
Yeah.
Yeah. Because I'm stopping her from exercising a right that she does have, but I'm also giving her money in exchange for her to stop it.
And that goes back to the very first slide we were talking about how contract is a performance or a forbearance.
Yeah.
That's
Yeah.
that's a contract where he is requiring her not to do something.
And it was implied because it was not written down.
Well,
Makes sense?
kind of. It's
expressed, right?
It is.
It's
Well,
expressed because it's mentioned in
it's
the
a blend.
Yeah.
But yeah, I can see where you're coming in from that. Yes, but it's more of expressed than implied.
Because he mentioned.
Because
I
I
actually
actually
expressed
this
Yeah,
amount.
it's more.
Yeah, so it's expressed.
It's more.
Now, had I done this, had I walked over to Miss Davenport, say at 3 in the morning, and I looked angry and frustrated and upset, and I just open out my checkbook and I write $10,000 and I hand it to her and I look at her like, you know what I want you to do.
Just say,
And
"Hey,
she
I'll-
stops it. I didn't say nothing. I just, here's $10,000. You know what I want? Kind of my look to her, and she stops. That's my actions, not my words. So then it would be applied. You see what I'm saying there? So that's
I always
kind
thought
of,
of expressed as explained.
Yeah.
And
that's a good way to look at it. Actually,
If it's explained, it's an express contract, whether that's oral or written.
Right. Everyone good on option contracts? Any questions? No? Mama? Okay. Guess what? Our last slide for the evening.
oh no, we have 50 more.
No, we do not.
We're gonna Travis's look up
We do
there.
not.
Next chapter 2?
No,
Awesome.
we're not doing 2 chapters tonight.
Let's keep it going.
Miss Davenport says she parties till 4, so
I
let's
say-
keep this going.
She can't party.
We got plenty of time, man. We got plenty of time. All right, last slide of the evening, land contracts. The purchase price is paid in installments to the seller, and the seller delivers a deed when the final payment is made. In other words, you don't get the deed to the house until it's fully paid off. And the installments is usually monthly installments, just like a mortgage.
So basically, let me explain this one just real quick, because I know you want to get out of here. A land contract is in this situation. Often it's going to be related to a seller's financing. Okay. So say, for example, that Sheldon, she has a house. Say that she has a house, she's flipped it, and she doesn't need the money. She's got tons of it, and she happens to just want some, like a check coming in once a month. Okay. So Wyatt decides, I want to buy that house. So Wyatt goes over, he does a seller's contract with, or a seller financing. Wyatt, you make your payments every month. At the end of your last payment, you then, in that particular situation, she would then sign over the deed to you at that point. But the entire time you're making payments, Sheldon keeps the deed and ownership, you're just possessing. Now, until it's paid in full. Now, what happens, Wyatt, if COVID hits and you're in seller financing and you lost your job and you can't pay her? What happens then? So say you paid 15 years, Wyatt. It was a 30-year payment to Miss Sheldon. You paid 15 years. You lose your job. You can't pay Sheldon. What happens? Huh?
She will be able to extend it.
If she's a nice lady.
Okay.
Sheldon's a very mean person. I just want y'all to know. Very, very mean. What happens?
That's a really good.
She kicks you out, keeps the 15 years of payments,
Starts it all
and
over.
starts all over to resell it.
You lost out in 15 years of payments.
Well, I figured that. I just don't know what to say because it's just a meeting.
Uh-huh.
It's terrible. It's a terrible thing that had happened.
That's why if you ever have a client that wants to do seller financing, you do not just use a basic 1 to 4 family with the seller financing addendum. You need to advise them to seek legal counsel because they need to know what they're about to get into. Because why you could be on your 29th year and 11th month and end up lose your job and lose all that money and it all be gone and you're screwed.
That's
See what I'm saying?
Better pull out that credit card.
Yeah, pull that credit card.
All right, that covers our stuff
Any
for the evening.
questions?
Does anybody have any questions online in class? Anybody? You good? We all good? All right, let's go ahead and stop the recording.
That was a lot of information tonight.
There's a lot of information. I know you're probably brain dead just